His DNA is all over that gun. When we heard from Ms. Taylor, we talked about the swabs from the grip of the Luger, and it's, in the state's view, important because this is a single source profile. There is no mixture. There is nobody else's DNA from the swab of the grip of this Luger, and it's Mr. Lyswick. And you heard Ms. Taylor talk about how in order to find another profile, or it would take us testing a quadrillion people to see a similar profile.
His DNA was all over that gun. Not a partial match, not a trace, a single source profile. The kind of result that would take testing a quadrillion people to replicate. And there are not a quadrillion people on Earth. He told the jury he had never seen the gun before. He had no idea how it got there. And then the science said otherwise. But that is where this story ends. Let's go back to where it began, because the road to that moment is longer, stranger, and more damning than a single DNA match has any right to be. Waukesha County, a murder trial. A man named Carlos Maldonado is dead. 2 gunshot wounds to the head, front to back. The shooter standing directly in front of him.
We may not know how far away Mr. Lyswick was standing from Mr. Maldonado when he shot him. We may not know which gunshot wound came first. But what we do know is that is the epitome of intent to kill. Because that is 2 times you have to pull that trigger. 2 deliberate times. And when we consider the trajectory that Dr. Scheel and Dr. Truesdale talked about when they used that probe, both trajectories of those gunshot wounds were in the right, up, and out the left. Almost as if they came in quick succession to have such a close trajectory to each other. Regardless, though,
the kind of shooting that forensic experts don't describe as accidental or impulsive or situational. The kind that tells a very specific story about proximity, position, and purpose.
And let's not forget about the fact that Mr. Maldonado was shot in the face. That is deeply personal. That is intent. That is, I am removing this human being from this earth. That is the target. And that is...
The defendant is a man named Lyswick, representing himself at trial. No attorney, no legal training. Just a man standing before a jury, trying to explain away a mountain of evidence with nothing but his own voice and what the prosecution would later call a very deliberate relationship with the truth. Prosecutor Thompson opened her closing argument by laying the evidentiary foundation piece by piece, and she did it with the kind of clinical precision that makes a jury feel they are not being persuaded, they are simply being shown. And there is a difference. Persuasion can be resisted. Being shown something real is much harder to argue with. Let's talk about what the jury was shown, because it starts well before April 14th, 2024, the day Carlos Maldonado disappeared. It starts in November of 2023.
Operation Slop Shop. We have dates on exhibit number 146, and it says targets identified. It goes back to November of 2023, and interestingly enough, when we look at those autofill sections on Mr. Lyswick's cell phone, that's when you start seeing Mr. Maldonado's name. And those autofills don't just happen. That is the user who has to manually input those names, and then the phone remembers it. Then we have him on exhibit 146, as the target of the first operation. And the numbering of all 4 of these operations is very important because when you look at exhibit 147, which is Operation Starling, It says at the bottom, the operation can commence since Operation Slop Shop is completed. Funds and reparations have been seized from Slop Shop, so for Starling, and all threats.
On Lyswick's cell phone, investigators found a document referred to in court as Exhibit 146. It had a name at the top, Operation Slop Shop, and it listed targets. Carlos Maldonado's name appeared in that document. More than that, his name appeared in the autofill data on Lyswick's phone, meaning whoever created the document didn't just write his name once and move on. They typed it enough times that the phone memorized it. Autofill, for those unfamiliar with how it works, is not passive. The phone does not remember names on its own. A user has to manually input a name repeatedly before the phone learns to complete it automatically. That detail is small. It is also devastating. But Exhibit 146 was only the beginning. The prosecution also introduced Exhibit 147, a document called Operation Starling. And at the bottom of that document, someone had written, "The operation can commence since Operation Slop is completed. Funds and reparations have been seized from Slop Shop. All threats from the first operation have been neutralized." The first operation. Carlos. Now, the defense at this point might argue this is circumstantial, that these notes prove nothing definitive about who wrote them or what they mean. And that argument might have some footing if the notes had been found anywhere else. But they were found in Lyswick's apartment. He lived alone. The notes referenced his brother, his mother, his personal history. They were, by every available measure, his. And when a jury hears the phrase, "all threats have been neutralized,"
Because when you look at Exhibit 147, which is Operation Starling, it says at the bottom, the operation can commence since Operation Slop Shop is completed. Funds and reparations have been seized from Slop Shop, so for Starling, and all threats from the first operation have been neutralized. That first operation is Carlos.
in the same document that names the victim months before his death, they feel something. They should. This is the nature of circumstantial evidence, and it is worth explaining here because it matters enormously to how this case works. Circumstantial evidence is evidence that requires an inference to connect it to a conclusion. A footprint in the mud is circumstantial. You did not see the person walk, but someone walked. A phone search for carcass removal 7 days after a murder is circumstantial. The defendant did not confess, but someone was thinking about a body. Circumstantial evidence is not weak evidence. Courts and legal scholars have noted for generations that circumstantial evidence can be, and often is, more powerful than direct testimony because it does not lie, cannot be coached, and does not have a motive to mislead. The prosecution's case was almost entirely circumstantial, and it was one of the most coherent bodies of circumstantial evidence you are likely to see in a trial of this kind. Now consider the timeline, because Prosecutor Thompson walked the jury through it with surgical attention to sequence. April 14th, 2024. Maldonado is last seen at a Home Depot. His phone records show he returned to the apartment complex at 1512 East North Avenue. And then, nothing. No movement, no sightings. He is wearing the same clothes in the Home Depot footage that investigators would later find on his remains. The trail cameras tell the next chapter. In the days that follow, Lyswick is captured on surveillance equipment moving toward the hill behind the apartment complex, the same hill where cadaver dog Moxie gave what is described in the transcript as a final response, meaning she detected the presence of decomposed human remains. He is carrying a shovel, boots, plastic sheeting, and what appears to be black garbage bags. He disappears from camera view for 30 minutes.
On those trail cameras then, 10 days later, with all of his gear, he's got his shovel, he's got his boots, he's got the plastic sheeting, he's got that black packaging with him that looks very, very similar to all of these black garbage bags. And he is up there for 30 minutes where we don't see him anymore, from 12:41 a.m. to 1:10 a.m. And when we see the direction that he's walking, it's exactly the direction up that hill. Because then when you go off camera, you continue going up the hill, or you can divert to that footpath where we eventually found Mr. Maldonado.
Then returns without the gear. Then, 10 days after the murder, a phone search, carcass removal, how to dispose of spoiled food safely. The prosecution noted this timing with a phrase worth holding on to. That timing is just too specific. And they are right. 7 days after a homicide, the defendant is not searching for how to handle dead animals on a whim. Context is everything when evaluating a search history. And the context here is a dead man on a hill.
We also then consider the phone searches from Mr. Lyswick's cell phone that we recovered during the search warrant on November 26th. What's interesting here, and what kind of overlaps with the trail camera videos, is that search on April 21st of 2024, 7 days after Mr. Maldonado was murdered, and about 10 days before we see him on that trail cam. He's searching for carcass removal, disposal, how to dispose of spoiled food safely. Sure, it could be innocuous, I guess, but not when you consider everything in the totality. That timing is just too specific.
Stop here for a moment, because you might be thinking, is this enough? Is a document with a code name, a trail camera, and a Google search enough to convict someone of murder? Here is what the answer depends on. It depends on what comes next. And what comes next is where this case stops being a collection of suggestive details and becomes something much harder to dismiss. We are about halfway through this story, and the DNA has not even entered the room yet. Weeks later, investigators follow Lyswick to a U-Haul and then to a storage facility. A facility he had no documented history of searching for until within 48 hours of Maldonado's body being discovered. He had rented the unit in November, the same month Operation Slop Shop identified its first target. He empties the unit on camera. He drives away. Officers stop his car. They seize it. They get a warrant. And inside the trunk, they find the murder weapon, a Luger pistol. In the back seat, boxes of 9mm ammunition, a shovel, boots, garbage bags. The physical remnants of everything the trail cameras had suggested was happening on that hill. The prosecution introduced the testimony of a firearms identification expert, Miss Crawford, who examined the 2 projectiles recovered from Carlos Maldonado's skull during autopsy. Ballistics is the science of matching a bullet to the weapon that fired it, using microscopic marks called striations, tiny grooves cut into the bullet as it travels down the barrel of a specific gun. Every barrel leaves a signature. These projectiles matched the Luger found in Lyswick's trunk.
The murder weapon. Inside that trunk, we find the shovel. In the back passenger seat, we have boots. We have numerous boxes of 9mm ammunition. So for Mr. Lyswick to say, I've never seen that gun before, I don't know what it is, I don't know how it got there. You certainly have a lot of ammunition for a 9mm. So then we also find all these garbage bags. We start putting all of these pieces together here. What's important to know, and really I'll sum up Ms. Crawford's testimony. She told us all about firearms identification and how we have those striations and those grooves and the manufacturing characteristics versus the individual characteristics. But here's the bottom line. These 2 projectiles recovered from Mr. Maldonado's body were fired from this gun. Period. End of story.
Period. End of story. Those were her words, recited by the prosecution in closing. But Lyswick told the jury he had never seen that gun before, didn't know how it got there, didn't know anything about it. And here is where you need to slow down, because what happened next is not just legally significant. It is the kind of moment that makes a courtroom go quiet. Miss Taylor, the DNA analyst, testified about the swabs taken from the grip of the Luger. Single source profile. No mixture, no secondary contributor. One person's DNA, and one person's DNA only, on the grip of the weapon that fired the bullets that killed Carlos Maldonado. The probability of finding that same profile in another individual? 1 in a quadrillion.
There are approximately 8 billion people on Earth. A quadrillion is 1,000 trillion. The number of people who would need to be tested before a matching profile might appear is 125,000 times the current population of the planet. Lyswick said he had never touched the gun. The gun said otherwise. It is not often that evidence speaks in a language this unambiguous. The DNA on the interior towel used to wrap the weapon was also a single source profile. His. The exterior towel, a mixture, still showed very strong support for inclusion at the highest reporting level available to the state crime lab. His profile appeared there too. The weapon was his. The DNA confirmed it. The ballistics confirmed it. And the notes, the timeline, the searches, the trail cameras, and the U-Haul trip had already built the structure that the DNA simply completed. Now, let's talk about the defense closing, because it is, in its own way, as remarkable as anything else in this case.
Lyswick represented himself, a choice that carries enormous legal risk. The phrase pro se describes a defendant who appears in court without legal representation, arguing their own case. Courts are required to give pro se defendants some degree of latitude, meaning judges are somewhat more forgiving of procedural errors when the person making them has no legal training. But there are limits to that latitude, and Lyswick found them, repeatedly, in under 5 minutes. His closing argument began with a plea for mercy. He described himself as a good man, a God-fearing Christian who simply wanted to go home. He said he could not identify anyone on the Hill on the night in question. He said the prosecution had taken broad liberties with the truth. And then he began introducing facts that had never been entered into evidence.
They don't know that I went home and that I was on a hike looking around for possums that lived in my yard and feeding my rabbits because I couldn't sleep that night, that I normally would put my tools down and go for a run up and down the hill or a quick trip to buy groceries at all hours of the day. During the daylight hours, I use a jogging suit. At night, if I'm out in my
I'm going to object at this point. This is all testimony and none of these facts are in evidence.
That's sustained. Mr. Lyswick, I caution you, you can argue inferences and argue what the state doesn't show in their evidence, but you can't testify about matters that have not been testified about. So just be careful that you're not trying to introduce new evidence.
The judge stopped him. Sustained. You cannot testify in your own closing argument. You can argue what the evidence shows. You cannot tell the jury things they have not heard from the witness stand. He continued. He raised the circumstances of his pretrial detention.
Ladies and gentlemen of the jury, I have been unable to present a hearty defense in this matter because I have been imprisoned in the Waukesha County Jail for 18 months now and isolated from my funds and my family and my friends and my ability to hire an attorney.
Okay, Mr. Lyswick, stop, please. Again, these are not matters for the jury to consider. They are to consider only the facts and evidence that was presented in the case, not what could have been, not what wasn't, only the facts and evidence that have been presented. Your status during the pendency of this case is not relevant and should not be matters for the jury to know. But you introduced it, but it should not be for them to know.
18 months in the Waukesha County Jail.
isolated from family and funds. The judge stopped him again. These are not matters for the jury to consider. They hear only what was presented at trial. Your conditions of confinement are not relevant. He continued. He suggested the Waukesha Police Department had a corrupt element, that finding him not guilty might prompt an investigation, that whoever actually killed Carlos Maldonado was still on the street.
I am a good man. I am a God-fearing Christian. I just want to go home. I want to resume my life. And when I go home, the Waukesha Police Department and anyone assisting them will be able to continue searching for the actual killer or killers of the poor victim in this matter. As long as I am in custody, they have stopped looking for who actually killed this man. Imagine that whoever did this is still on the street. I implore you to please send me home. Find me not guilty in this matter, because I am not guilty in this matter. And owing to the corruptibility of people and human nature, I am telling you there is a corrupt element within our local Waukesha Police Department. And if you find me innocent, perhaps there will be some house cleaning.
There's a specific phrase that legal observers use to describe what Lyswick attempted in that closing. Jury nullification is when a jury decides to acquit a defendant not because the evidence fails to meet the legal standard, but because the jury disapproves of the law, the prosecution, or the system itself. It is rare, it is controversial, and it almost never works when the evidence against a defendant includes a single-source DNA profile on a murder weapon. Here is the question this case invites you to sit with. When a defendant chooses to represent himself and then attempts to introduce new facts during closing argument, is that a strategy or is it desperation? Because there is a difference, and the jury sees it in real time. The prosecution's rebuttal closing lasted approximately 90 seconds.
What I'd like to posit to the jury is there's probably someone else who really wants to go home or wanted to go back to his apartment that night.
I object, Your Honor. She's already had her chance to make her statement in this matter.
The objection is overruled because the state bears the burden of proof in this case. It is allowed by law to give a closing argument and provide a rebuttal closing. So the state gets the last word. Attorney Thompson, you may continue.
Thompson said one thing. There was probably someone else who really wanted to go home that night. Carlos Maldonado had plans with his daughter.
Mr. Maldonado had plans with his daughter, and she never anticipated that he wasn't coming back to his apartment that night. And so who's responsible for that? Mr. Lyswick. So let's all remember why we are here, because Mr. Lyswick murdered Mr.
He was not expecting to die. He did not come back. Lyswick objected to the rebuttal. The judge overruled him. The state, he explained, bears the burden of proof. And because it bears that burden, it is entitled by law to speak last. The prosecutor gets the final word, always. That is not an accident of procedure. It is a deliberate structural protection for a system that requires the government to prove its case beyond a reasonable doubt. Reasonable doubt. Not any doubt. Not all doubt. The standard is specific. It is the doubt that a reasonable person would carry after examining all of the evidence, not the doubt invented to avoid a difficult verdict.
Your status during the pendency of this case is not relevant and should not be matters for the jury to know. But you introduced it, but it should not be for them to know. So focus on the issues here and the evidence that has been received in the trial this week, and you can continue your arguments.
Your Honor, you noted these protests throughout the trial.
I have. Now continue.
Ladies
The bones tell a story, said forensic expert Dr. Trudell, and the prosecution borrowed that phrase to close. All of these pieces of evidence tell the story of how Carlos Maldonado was murdered and then hidden so that no one would find him.
The jury heard that story. They had the notes, the timeline, the trail cameras, the searches, the shovel, the garbage bags, the ballistics, and the DNA. They had a defendant who claimed the gun was not his, while his DNA covered every surface of it.
Here is the lesson this case carries, and it is one you can use. If you ever find yourself on a jury, or watching a trial, or evaluating whether someone is telling the truth, remember this. The most dangerous moment for a defense is not when the prosecution presents its strongest evidence. It is when the defendant contradicts that evidence with a statement the jury can immediately test against something they have already heard. A single-source DNA profile is not an abstraction. It is a number. 1 in a quadrillion. That number, sitting beside the statement, "I have never seen that gun before," does not require a law degree to evaluate. It requires only the willingness to hold both things in your mind at the same time and ask which one can actually be true. Evidence does not plead. It does not perform. It does not appeal to sympathy or invoke God or warn about corruption. It simply exists. And when it exists in sufficient quantity and consistency, it answers the question the jury was always there to answer. Carlos Maldonado deserved to come home that night. The evidence explained why he didn't.
Pieces together, just like Dr. Truesdale said. The bones tell a story. They tell a story about someone's life. And all of these pieces of evidence here tell us the story of how Mr. Lyswick murdered Mr. Maldonado and then hid his body so that nobody would find him and hopefully he would get away with what he did.